What's happening? Of course, you know it's your boy B Hot Radio Shout In. Stepping in the building, I got a friend and family member to the show off in this thing, Nicci Gilbert. Daniels, what's going on with it, sis?
I'm back in the building.
Welcome back.
Thank you, brother. Thank you.
You know, last time we talked, you know, one of the main things that you were discussing, Nicci, was just having control over your IP out here in these streets. I mean, I know you've been going through the battle with P Valley and everything else.
Yes,
Where
sir.
are we at with that right now?
Well, sir, we going to the Supreme Court.
Okay.
And a lot of people are like, this child going to the Supreme Court? What the hell? And we're going to the Supreme Court because at this point is much bigger than P Valley. Like you mentioned, you know, like the movie Centers. I don't know if you had a chance to see it, but you see the conversation that came up with Mr. Ryan Coogler about ownership and the fact that he's able to retain that ownership. What is it, 20-some years later, or whatever. And what's really interesting, before I forget to say this, make sure y'all check out, if you're an artist, if you're an author of any kind, make sure you check out that 35-year copyright reversion situation, right? I'm not a lawyer. I'm not going to play lawyer here today, but there are certain things in place to protect authors and songwriters and musicians, no matter what your contract is. There is an act specifically that was created so that after 35 years, every 35 years, it reverts back to you or to your heirs or whatever, right? Yeah. So P Valley. So a lot of people don't know. Last time I was here, I think we were just kind of getting into it, right? Yeah. Case started out in Georgia. The judge in Georgia sent it over to California. Okay. And what's really interesting is that judge sent it over to California because he felt like there were people in L.A. He did not dismiss the case. Yeah. He said, no, we're going to send this over to California because there are defendants who need to show up to court. Yeah. They'll be easier to subpoena. So we're thinking, okay, this is not such a bad thing when we found out why the judge sent it over. Yeah. So as soon as it got to California, the judge there ordered the defendants to file their motion for dismissal, to refile it as a motion for summary judgment, which was shocking and really unheard of by my attorneys and a lot of the other attorneys that I reached out to, because judges don't normally order defendants to file summary judgment. So what a summary judgment is basically saying, nothing to see here, this is frivolous, get this out of here, there's nothing. Yeah. Now, we didn't have an opportunity to go through discovery. We didn't have an opportunity to, ask any questions. It was just get it out of here, right? So that immediately put me in sort of a space of like, okay, what's happening here? Which is why I instantly went to, all I want is a trial. Yeah. All I want is due process. All I want is my constitutional right. Exactly. I'm not saying one way or the other what the jury is going to decide, but I need to go before 12 triers of fact and present my evidence. Well, lo and behold, he asked them to file it, or ordered them to file it as a summary judgment motion. They did. We went back and said, well, since you're giving them the option of filing a summary judgment motion, can we do discovery? He said no. Right? So we're like, well, wait a minute. You tell them to file summary judgment, then you tell us we can't have any discovery to get more information. How do we fight this? So then, I don't know what happened, but he had a change of heart and said, okay, well, I'm going to give you guys 60 days to do discovery. Now, discovery could take up to a year in most cases, right? 60 days is a very, very short period of time to be able to go and say, hey, let's talk about this case to your defendants, right? Now, mind you, when you file a case in a court of law, I'm just giving y'all a little law school, right? Or just what I done learned in these 5 years.
I'm here for it.
When you file a case in a court of law as a non-moving and a plaintiff, they're supposed to automatically see it in the light most favorable of the plaintiff, right? So they're supposed to believe the plaintiff, and the burden of proof is on the defendants, right? So in this instance, I'm in LA. The judge says, no, you can't do discovery, then says, okay, I'll give you 60 days. So what do we do in that 60 days? What is probably going to be most effective? Number one, we asked to depose Katori Hall, the CEO that I left my materials with, and Nico from the cast, since he was the longest running cast member. Thankfully, the deposition is not handled by the federal judge. It's handled by the magistrate judge who works with the federal judge. She said, absolutely, you can depose these people. So we did a deposition, which y'all will never see because the judge redacted it. Said there's nothing to see here, blacked it all out.
What?
I feel like there's plenty to see. I feel like if the public was able to see what Katori said and what the CEO that I left the materials with said, if the public was able to see these things, the triers of fact were able to see these things, I feel like I'd stand a chance at trial. Yeah. But they can never see them because they redacted everything.
Oh, my God.
In addition to that, we hired an expert because the rules state that where you have a complex case where there are nuances and stories and whatever. Yeah, Nicci, there's your side, but let's get an expert involved so that they can look at it and determine. And the reason I wanted an expert, Beehive, is because I want you to tell me, do I need to keep pushing forward and risking everything doing this?
Exactly.
Don't lie to me. Tell me what it really looking like, right? You feel me? So the expert comes in, it's like, I've never seen anything like it before. This is no question, unequivocally, there's no way this could have happened without them having access to your materials. Now, mind you, my meeting was set up by my then attorney, who was friends with the CEO that I met with, right? So you got lawyers referring to other, you know. So that's easy. They didn't deny the access. What they decided to go with is, these are not similar. There's nothing in here that is the same.
Oh my God.
So we said, okay, well, let's just say that of the 57, you know, half of them were debatable, which I believe they were all on par, as did the expert. The judge went in and went through it and said, see, Nicci, your character, well, he didn't say see, Nicci. Here I am in my Beehive voice. He did not say see, Nicci. He said, the plaintiff claims that the two lead characters, Tata Burlesque, who I created in 2004, and Uncle Clifford, are the same, right? Now, mind you, the reason he is saying they're not the same is because he said, my character is a gay man who doesn't wear dresses. He said, although in the description it does describe him as a drag queen and a den mother, he doesn't use her pronouns. Uncle Clifford uses her pronouns. So that makes them so different that nobody would see that they were the same. So we thought, well, that's an issue of gender identity, right? If you are a man and you sleep with other men, you are gay. Uncle Clifford is a man who sleeps with other men. That makes him gay.
That's right.
And also, Tata in French is slang for auntie. And we didn't call him Auntie Burlesque. Because in 2004 and 5, before those pronouns became more clear, it was offensive. Which is why we weren't saying you're a drag queen or you're a cross-dresser or whatever, right?
Exactly.
But the bottom line is, you have two men who sleep with other men who run an erotic venue that is typically something that is run by straight men because it caters to straight men. So that in and of itself, with the two lead main characters, should have been enough to say, okay, these characters are similar. But instead, the judge made the determination that they were nothing alike.
Oh my God.
They also said, well, you only mentioned the casino takeover twice in your play. Well, my play is 2 hours. Their series is 8 to 10 hours. Right? So they have much more time to build our story. But because my casino development, which was established at the very beginning of this play as the whole entire reason, the homophobic antagonist, both shows have a homophobic antagonist. The judge says, yeah, but your homophobic antagonist is more homophobic than their homophobic antagonist. No, literally. He said, P-Valley's homophobic antagonist, which is the character Isaiah Washington. Now, they both wore the fedora. They both drank from a flask. They both smoked a cigar. They both used the inside man to take over the club. They found that no reasonable human being on the face of the earth, no reasonable juror, would look at any of this and say, there are no similarities here. There's nothing to see. So he threw the case out, and not only did he throw the case out, he said I should be pretty much ashamed of myself for even bringing it to his courtroom. So he ruled in favor of the defendants. So now I am liable to paying them millions of dollars in legal fees because I trusted a system to go in and say, hey, listen, I'd like to go and have my due process rights. I'd like to be able to go and sit before 12 jurors and present my evidence. You can't present how do you do it? You can't present the fact that you sat and met with the company that puts the play on and you left all your materials. We're going to ignore that. That doesn't even count. We're also not going to do the expert who has 30 years of experience as an expert. We're going to get rid of their report. That means nothing. And we're also going to say there are no similarities here. And everything Katori said and everything the CEO said and everything Nico said, we're just going to redact that. Nobody's going to see that. Nothing ever happened here.
Oh my
and
God.
You've been mischaracterizing the story you wrote the whole time. None of the things that you're saying in this story actually coincide with these two stories. Now, mind you, every attorney, the tens of thousands of people who have watched the side-by-side comparisons, the fact that both stories have the same exact beginning, middle, and Inn. New girl arrives with a red vintage suitcase in Soul Kittens. New girl arrives with a red vintage suitcase in P-Valley. New girl gets hired on the spot, goes over to a rat. All of this sequence of events, the exact same. New girl saves the club in the end. A homophobic, cigar-smoking antagonist going after a gay man who owns the club because it's worth millions of dollars because of the land it sits on. Gentrification happened in Detroit, where I'm from. Casinos were built and took over those small venues where I'm from. He said Detroit was not impoverished. Your story didn't have as much poverty. Didn't have as much, it was a high class venue. I'm like, Detroit just got out of bankruptcy.
Yeah.
Detroit and Memphis are sister cities in regard to the inner city aspects of it. So without getting into the weeds too deep, I was denied at the district level. And then it went to the appeals court, right? Which the interesting thing about the appeals court is I really believed I had a chance because what's interesting, and I became a little baby lawyer.
Yeah.
One of the appeals court judges, her name is Judge Wardlaw, she made a very, important point. She said in a trial about copyright infringement, right? I believe it was the Zendo case. She said, I think it's hubris for district judges to sit in chambers and make decisions about cases as if they were experts, as if they went to college for it, as if they are creatives. There are cases that are so frivolous, but in most instances, summary judgment is not an appropriate time to just deny a person an opportunity to go to trial. And I had hoped going into the appeals court that I would get that same sort of, baby, I went into the appeals court on the 6th. My lawyer could barely stand. He was super duper ill.
Oh my God.
10 days later. Now, usually these things take months and months and months. 10 days later, nope, nothing to see here. We're going to throw this thing out of here. I'm like, wait a minute.
Oh my God.
And they said things like, yeah, well, the judge said you only mentioned a casino twice, and you do only mention a casino twice. Why? Because it's a 2-hour stage play. It starts with them saying, I know why you want this land. I know how much money this land is worth. And the entire role of the antagonist is to take it over so he could build a casino. They're like, oh, no, he didn't really want to take it over to build a casino because he didn't mention it 10 times like they did in P-Valley. So I learned another thing, which we all need to be clear of. When you go to the appeals court, there's something called a high degree of deference that they have to give the judges. Yeah. Meaning, we have to assume what this judge has said and done is correct, right? So that is what they did. They gave a high degree of deference, and we were like, well, there's a little judicial overreach. Maybe we need to nothing. But what I learned, the story's not all bad. What I learned is that there is no rule established in copyright law, in IP law. Right? So they have this method called the Dubert standard. And in that method, it was based on a pharmaceutical company case. So they're trying cases about creativity and art and film and music and literature. And they're requiring standards that were established in pharmaceutical cases. Or a music case from way back in 1972. Yeah. There are no real rules established today that protect creatives, that say, hey, listen, when you go into a trial court, you can bring an expert report and it'll matter. Yeah. We believe that it is, what is the correct legal term? Abuse of discretion is what they call it. When a judge sits down and makes creative determination, complex, analytical, creative determinations, things as simple as the reason we didn't mention the casino 10 times is because we had 2 hours in a stage play. Oh, but your stage play was brighter, and it was like, because people have to see it. Because people have to see it on a stage. It's not a film. It's not a TV series. We don't have a $100 million budget. Yeah. But the very last thing we leaned on was this thing called a Metcalf analysis, which means if you take all of because what they basically, I left this out, it's very important. I don't want nobody checking my podcast and being like, but she left out some important information. They created this word called scenes of frere. So what scenes of frere is basically where you take, if we're doing a podcast, we know it's going to be water, we know it's going to be a mic, we know somebody going to come in and probably spill some drama, whatever. But there's certain elements, if they are arranged in a specific order, that constitute infringement. So if you take all of these things that happen in a regular restaurant and all these things that happen in a bar, and they happen chronologically, like in the same pace and order, then you should be able to go to a jury to present it to them and let them decide. They said, no. Even though, again, $100 million budget, the same beginning, middle, end. Girl arrives out of nowhere. Homophobic antagonist tries to take over. He can't take over. In the end, a girl saves the club. The same amount of characters are represented. It's 5 women. It's a handsome bartender. It's a homophobic. If you took and lined them up, they all line up.
Oh, my God.
Side-by-side chart comparison. So, the good news about the Supreme Court, and I know folks be like, if she don't let this go, if I let it stay where it is, anybody coming after me, any other artist, any other creative coming behind me, they're going to say, well, the Nicci Gilbert case had 57 comparisons, and that didn't fly. The Nicci Gilbert case had an expert, and that didn't fly. Nicci Gilbert went and presented her evidence to the company that put on the play, and they still didn't care. So how does any creative going forward that says, I went and I sat down with this company and I gave them X, Y, and Z, and look at all of these you don't stand a chance. Now, the good news is we know. So we could save the next family from losing their house or from being charged millions and millions of dollars. But is that really constitutionally correct for a person to be denied due process? Imagine Diddy can't go and present his evidence. Say what you want to say, feel how you want to feel. The man still gets a right to a trial. You defend your property. You defend your family. I have not had that opportunity. And I haven't been given that opportunity because a judge decided he was going to act in the role of a trier of fact and a creative and tell me I'm mischaracterizing what I wrote 20 years ago.
Oh, my God.
And it's just, the Supreme Court question is, was my due process denied? Because you have to present questions. Was my due process denied by not being given the opportunity to go before triers of fact? And also, there's a conflict within the circuits because there's certain judges and certain circuits that say, no, this would pass on my watch. This would go on my watch. But then there are other circuits that go, no, we're going to do X, Y, Z, A, B, and C. And then they establish a precedent, for lack of a better word, and then they deviate from it. So the you playing a game, and it's just, the rules are changing. Oh, my God. As you're going up the field.
Exactly.
So we just need to get a clear understanding on what that is. I'm going pro se, meaning I'm taking this to the Supreme Court by myself. Okay. But my writ is damn good. Don't let that fool you.
That's right.
Because I've been in this for 5 years. Now, I did hire a company this go around because they sent it back and was like, okay, so we need you to just, first of all, I need to be this size, not this size. And, you know what I'm saying? Certain little big elements. But I did hire a company, and we're probably, by the top of next week, you will be able to see it publicly on the docket. Yeah.
Mental health, though, Nicci.
Let's talk about it.
When they come back to you see what I'm saying? And they say, you know what? We want to charge you millions for this. Right. And you obviously can show the comparisons and everything that's going on. I mean, they could have just said, all right, we're going to let bygones be bygones, and then you can figure out something later on. But, they come back and actually reverse it and attack you.
Yes.
What was going through your mind at that time?
Disbelief. Complete and total. Well, you know what? It wasn't complete disbelief. It was disbelief that I could not go to trial. That's when the first thing happened. When I realized they weren't going to let me go to trial, the defendants gave me an out from these fees. So let me be clear.
Okay.
If you don't file an appeal, we can let it go.
Ooh.
So if I would have just said, okay, I was wrong, nothing to see here.
Yeah.
So I'm not, let me be fair and make sure I tell the whole truth. I was given the option.
It's part of the fight.
Of not paying all these extra fees.
Yeah.
I believed in the judicial system.
Yeah.
And I believed that I had a constitutional right to 12 jurors.
That's
and
right.
I only need 7. Right?
Yeah.
I believed that this conversation was worth having because ownership of intellectual property that we create is how we build generational wellness, talking about mental health and health.
Exactly.
So the fact that I realized that they were not going to let me go to trial, I was mentally preparing for all the other stuff. Now, hearing that while I learned that my sister had terminal brain cancer,
oh my God,
was the most devastating shit I ever experienced in my life.
Yeah.
right? But then I had two choices, right? My choice was to either be human and let this shit break me all the way down or go absent without leave.
Yeah.
Right?
Yeah.
Or to be like, this is what they want me to do. They want me to fall apart. So thankfully I got a husband I can fall apart with.
All right now.
You understand what I'm saying?
Yeah.
And I got family members that I can fall apart with.
Exactly.
And then they be like, now wipe that shit up, straighten up your back, and go do whatever. And it's a struggle every single day.
I bet it is.
To know that I've been in the business for 30 years. I've dedicated my life, and this isn't the first time. They did it to me with R&B Divas. But then I have the fact that I now own the IP for R&B Divas to lean on 11 years later.
Okay.
So there are things which has always happened in my life. From getting stranded in the desert in the middle of nowhere and then meeting Michael Jackson after that. You know what I'm saying? So my faith.
That's right.
Like the real faith, like
That's
not
right.
I got faith the size of a mustard seed.
Exactly.
Mine is in some watermelon space right now. You understand what I'm saying? Because it's brutal. It's the most painful shit ever. Some days I wake up mad as hell. I'm like, okay, who gets it today?
Yeah.
You know what I'm saying? But not from a like just random. Who of the people who have done wrong?
Yeah.
Get it today, which is why I leverage social media the way that I do. Plenty of people are like, this girl just keep bringing, these days, nothing gets accomplished at any level, from presidency on down, without awareness through social media.
Exactly.
And if there were more awareness, in my case, things would have been different.
I agree with that. Getting your IP back for R&B Divas, how did you go about doing that?
Baby, listen. While I was taking care of this here business, so just realizing, we learn about copyrights, we learn about IPs, right?
Yeah.
But what you don't always know is your trademarks, right? That's something new. That's something that we just kind of figuring out, this trademark thing. So MC Light, my soror, hit me and she was like, I got my MC Light, and she posted on social media. She's like, I own the trademark to MC Light. You need to go and get that for Brownstone. You need to go and get that.
Yeah.
So I'm working on Brownstone. I'm working on Worth TV. I'm working on. So as I'm talking to the trademark attorney, I said, hey, can you check I know this is a shot in the dark, but can you check to see if R&B Divas is available? It had been abandoned for like 7-8 years.
What?
And when you abandon the trademark, it is
you can
made
get
available.
it picked up. Yeah.
Do you understand? So she was like, oh, bloop. And I was like, thank you very much. And here's the thing.
I know that's
Here's the thing. With R&B Divas, I'm really open to, it's not like I own the trademark. It's not, because at the end of the day, it's an ensemble, it's a cast, you know what I mean? But as the creator of the franchise, as a person who brought everyone together, as a person, this idea came from me.
Exactly.
I deserve some partnership and some ownership in that.
That's right.
Now I retain all of it. I'm willing to share with, specifically TV One, and I've been having conversations about how to really make this thing go.
Okay.
Because you want it to continue.
Exactly.
Do I ever want to be on camera arguing with people again in life? No. But I'm not going to stand in the way of folks who do.
Exactly.
Especially when I need mailbox money.
Come on now.
Go ahead, have that argument, sis, if that's what you feel like you need to do. Now, of course, we don't want it to go too far off the rails.
Yeah.
But I learned the valuable lesson of let people be who they are and live how they live.
Exactly.
And don't try to rescue my husband, listen, my husband was telling me from jump, worry about you. Stop being so concerned about what this one doing over here and
That's
trying
right.
to uplift and hold, but because when it break down for you, you go see who there.
Exactly.
And he damn sure wasn't lying.
Come on now.
I said, damn, I'm on fire because somebody spit on me or something. Damn.
Yeah.
And that's not how it went down. So at this point, for me, it's all business.